Members, you're all very welcome back to our first meeting after recess. I'll just make you aware that in the room with me today I have the Vice Chair Kelly Armstrong and I have Andy Allen. I can't really see the Starleaf on my screen, but we have Sinead Innes and Mark Durkin on Starleaf as well. Can I then, we do have apologies, sorry, I'll move to agenda item 1. We have apologies from Pam Cameron, Fran McCann and Karen Mullen. Can I ask, is there any other apologies? I know I was speaking to Alex and he had said that he was coming this morning, so we should expect him at any time soon. Members, I'll move on to agenda item 2, which is Chairperson's business. We are only meeting until 11 a.m. this morning because the starlight from this room is used for the chamber, as members are aware. So that means that next week's meeting will also have to start at 9 a.m. to allow us to catch up. I'm sure you're all very glad to hear that. So we'll get moving on and we'll try and get through as much business as we can today. Members have been informed that the Minister is proposing to host an event on the 13th of October for our Olympians and Paralympians and is seeking 2 MLAs to show cross-community support. I am more than happy to provide my support. Can I get agreement from another committee member to support this event? Andy, thank you very much. Then, depending on restrictions in place, the numbers of MLAs invited may be limited. However, at the very least, the Minister would like to extend an invitation to the committee and we'll keep you all posted on that. So if you can put that diary date in, it's the 13th of October. We don't have a time yet down here, but we'll let you know as soon as we get the details. Members, Housing Rights are holding an online seminar on the 29th of September. It's entitled Where to Next for Security of Tenure in Northern Ireland's Private Rented Sector. It will focus on the Private Tenancies Bill, in particular security of tenure and notice to quit. I propose we request that a member of RAISE attends and reports back to us as part of the bill gathering evidence. Members in agreement with that? Agreed. Yeah, okay. Going to move on then to agenda item 3, which is draft minutes. Members, you'll find the draft minutes of the 8th of July 2021 at page 16. Can I ask, are you content to agree the minutes of the 8th of July as drafted? Agreed. Agreed. Thank you. Moving on then to agenda item 4, which is matters arising. Members, correspondence was regularly sent out, as you know, during summer recess, and members were asked to highlight to the committee team any correspondence that they wanted to discuss further. The committee team has not received any specific requests from members, but I'd like to bring up the departmental response dated the 20th of August on the WICT project. And I know, Kelly, you'd want to discuss this under any other business, and I also know, Andy, you have been working on this for many, many months, as the committee have also written letters on that. I note from the response it's still not very hopeful about the continuation. Yeah. I know that the Minister is hoping that a scheme will, it looks like a newer scheme will start, but from what I can gather, there seems to be a break there. So, members, what do you propose that we do on this, Andy?
I propose, Chair, I know we obviously are pressed for time moving forward with the bills, but in the first instance, we invite TWN to come and brief us. I know some of the members have been engaging with them, but we'll get a fuller picture from them, and thereafter we can decide what engagement strategy we have for the department.
Yeah,
members in agreement.
I'd agree with that. I know TWN did write to me as chair of the committee, and I'd sent that on. That is in our pack this week under correspondence as well, as a matter of urgency to come in and brief the committee. So I would be supportive of that, Kelly.
Thank you, Chair. I met with the WICT programme partners. Very frustrating. Their funding is due to end at the end of September. The funding is there, but we don't know from the department yet how this is going to move forward, whether it's going to be a contract. If it is going to be a contract, that needs 3 months' notice to be able to put out, or if it's going to be a grant. Any break in the programme will lose some of those women who are not formally connected to any other groups. I would be concerned about that. I just feel that there seems to be a disjoint between what the department are saying and what the partners have been saying. There doesn't appear, and I couldn't find it anywhere, a complaint or a negative report from the department about the programme, other than to say that they haven't been delivering and therefore, something else is coming in. So it would be interesting perhaps as well as having the WIC partners in, is to ask the department themselves for an update why they're taking a different approach to this. Has there been something wrong? Have the partners been notified of what was wrong? Because I don't want to leave women without anything.
No, I agree. It has been a very successful programme, and it has been very, very beneficial for so many women, and we don't want to leave that hanging. So if members are in agreement, we will ask for them. I know we have a lot of business on next week, but I think this is an urgent one that we need to slot this in to our agenda for next week, and also ask the department as well for an update. Are members in agreement with that?
Agreed.
Yeah? Okay. All right, members, we're going to move on then to agenda item 5, which is the Charities Bill. Members have been provided with a copy of the Delegated Powers Memorandum at page 33 of your pack. Members, are you content to forward a copy to the Examiner of Statutory Rules for comment?
Agreed.
Agreed, thank you. Then at page 39 is a letter from the Irish Charities Regulator. The regulator is unable to orally brief, but states that a written submission will follow. Can I then ask our members content with a written submission?
Agreed.
Agreed, thank you. Move on then to agenda item 6, which is a raised briefing on the Charities Bill. Members, again, you've been provided with the Charities Bill research paper at page 112 of your pack. And then can I welcome to the meeting Stephen Orme? Stephen there?
Yeah.
Yes, he is. Stephen, you're very welcome. I understand that you recently became a daddy and you're on paternity leave, so we're very grateful that you were able to come and brief us while you're on leave, brief the committee. So, sorry, I'll just bring Andy in first.
Sir, can I declare an interest as a charity trustee, please?
Absolutely, thank you, Andy. So, Stephen, if you want to go ahead.
Sure, yeah. I'll just check everybody can see and hear me okay, just do that usual check.
We can indeed, yes.
Okay, so as you've covered there, this briefing addresses the Charities Bill as introduced to the Assembly in June of this year. I'll first cover the background to the bill briefly in terms of the current or the existing legislation and the court judgments that have informed the drafting of the bill's content. I'll then cover each of the 3 clauses in the bill as it stands and exactly what they do. And as I do that, I will highlight what are called issues for consideration in the paper, and these are just issues that the committee might wish to consider as part of the bill's scrutiny and development. And then finally, I'll briefly touch on some potential financial implications of enacting the bill. That's a standard thing that Rees does with all legislation. It's not a massive issue with this bill, but essentially that's just a handful of costs and savings to the public purse that could arise from putting the bill's provisions into practice. So the Charities Act Northern Ireland 2008, which I'll refer to as the 2008 Act, is the current foundation of charity law in Northern Ireland. It was passed in 2008 to update and harmonise charity law at a time when that was also happening in England and Wales, Scotland and the Republic of Ireland. And that Act established the Charity Commission for Northern Ireland. So in 2013 then, the Executive and Assembly passed a further Charities Act, which I'll refer to as the 2013 Act. And this was to correct technical issues with that original 2008 law. So the 2008 Act established a public benefit test. In essence, that meant that a charity's purposes must be in some way for the public benefit. But the legal definition of that test was originally taken from Scottish legislation and wasn't specific to Northern Irish law. So the 2013 Act then revised the legal language underpinning the public benefit test to make it more specific and practical in Northern Irish law, and this permitted the Charity Commission to start registering charities. So the key issue with the 2008 Act as it relates to this bill is there's no explicit provision in the 2008 Act which allows for the Charity Commission's functions to be performed by its staff as opposed to the commissioners themselves. At the time the 2008 Act was passed, the law in England and Wales and the law in Scotland did have a provision allowing their staff to perform functions, and then in addition, draft law under consideration in the Republic of Ireland at that time also had that provision, and that's now the law in the Republic as well. So the first issue for consideration raised in the paper is, why is this essentially? So why did the 2008 Act differ from law or draft law in England and Wales, Scotland and the Republic of Ireland in this specific way? And then in 2013, when the Department for Social Development, as it was then, went back in to fix the 2008 Act in respect of the public benefit test, was this issue recognised or considered at that point? So, post 2013, this issue of staff's ability to perform commission functions was then the topic of a High Court of Justice ruling in May 2019, and I know committee members will be familiar with that. But very briefly, in this case, the Charity Commission and the Department for Communities maintained that the Commission did have the power to delegate its functions to staff. The Court, however, and in absolute essence, found that the Commission had no express or implied power to delegate functions to staff. The Court of Appeal then upheld that decision in February 2020, and taken together, those judgments made around 7,500 orders, directions and decisions taken by Commission staff as unlawful, and have also prevented Commission staff from performing any functions under the current legislation since that point. In practice, this has drastically reduced the scope of the Commission's powers and capacity. So the bill itself then has 3 clauses. 2 of these directly address the court judgments and work to repair the law in effect, and the 3rd would empower DFC to create a charity registration threshold. So we'll discuss each of these in turn. Clause 1 amends the 2008 Act to treat Commission actions to commit. It amends the 2008 Act to treat Commission staff actions taken before the High Court judgment as actions of the Commission itself, and in practice that would make those staff decisions lawful. Now that doesn't apply to all decisions. There are several exceptions to that clause. For example, if a staff decision was to publish an inquiry report, or remove charity trustees or employees, or disclose information under Commission powers, those would remain unlawful under the bill. So the committee might want to consider, why is it that some staff decisions remain unlawful? And did the department consider any other categories of staff actions or decisions that could have remained unlawful in that way? So where a staff decision is made lawful, and it would ordinarily be an appealable decision, the appeal window will be refreshed to start on the day that the bill receives royal assent, and this effectively allows 6 weeks from the date of royal assent for a fresh appeal to be lodged. So the committee might want to consider then, is that long enough for appeals to be lodged, and do the department or commission intend to contact any affected persons or charities to notify them of the refreshed right to appeal and the time frame for that? And then finally, in relation to clause 1, where a staff action is the registration of a charity, that charity will only have to submit accounts and reports from April 2022. So in effect, charities won't suddenly have to jump back and provide accounts for previous years. I know that's been an issue that Charities and NIPSO and the committee itself have raised previously, so that is addressed in the bill. Clause 2 of the bill then amends the 2008 Act further and explicitly allows for commission functions to be performed by staff in the future. So again, there are a couple of restrictions on this. First of all, any delegation to staff must operate within a scheme of delegation published by DFC, and in effect this can be understood as statutory guidance from DFC. In addition, the bill establishes that there are several things that staff can never do and are effectively reserved to the Commission, and these might sound familiar from what Clause 1 has, but starting or publishing an inquiry into a charity, suspending or removing charity trustees or employees, and then the making of regulations by the Commission, those would all remain things that only the Commission itself can do in future under this bill. It is worth noting that having specific exceptions to a staff delegation power like that would be unique to Northern Ireland. In England and Wales, Scotland and in the Republic of Ireland, there are no such exceptions in the law. When the Court of Appeal upheld the High Court's judgment in 2020, they advised that, and I'm quoting here, but they advised that careful consideration should be given as to whether any of the powers and functions in the 2008 Act can properly be discharged by staff, and if so, then that should be reflected in what they call unambiguous language. So that would appear to be why there are specific exceptions to staff powers in this bill. The Court of Appeal specifically advised the Department and Commission that any change to the law should be clear and unambiguous. But still, it is worth noting that we would be different, we would remain different from the law in Great Britain and the Republic of Ireland on this front. So, in relation to Clause 2, the committee might want to consider a few things, in particular, if the department could confirm why certain functions are permanently excluded from staff, when that's not the case across the rest of GB and in the Republic, and was any consideration given to any other functions being excluded from staff? Secondly, where a function is excluded from staff and is therefore reserved to the Commission itself, How will that work in practice? Will staff be involved in supporting the commissioners to reach decisions in those areas through, for example, providing advice or information or staff support kind of services? And if so, would that be covered by any scheme of delegation that is required to be produced by the EFC? And then finally, are the Department and the Charity Commission happy to consult the committee on the detail and operation of a scheme of delegation? So clause 3 then, finally, in terms of the bill, would empower the Department to pass regulations which would establish a charity registration threshold. So it's important to understand that the bill itself doesn't create a threshold, it just gives the Department the power to do that at some point in the future and with the Assembly's consent. So basically, charities below a certain level of income or assets wouldn't have to register with the Commission and could then be exempted from other requirements like submitting accounts, for example. These regulations would initially be subject to the affirmative resolution procedure in the Assembly, and that means that the Assembly must actively approve them before they come into force. Once the threshold is in place, however, the bill would allow the Department to change the level of this threshold and regulations using only the negative resolution procedure. Under negative resolution, regulations automatically come into force unless a member brings a motion to the Assembly floor and the Assembly actively votes the regulations down. In practice, that happens very rarely. So the committee might want to consider, therefore, if they're happy with the Department being able to change the level of any threshold once it's created by a negative resolution, or if they prefer a procedure which requires active Assembly approval of a change in the threshold. I know immediately before my agenda item, there was reference to some correspondence with the Examiner of Statutory Rules, and they would probably be the person to ask about that if that's something the committee are interested in. And then finally, in terms of clause 3, the committee might want to consider whether clause 3, permitting the Department to create a registration threshold, is appropriate to include in the scope of this bill. So the bill's primary aim, as I've said, and as the Department have kind of said at the outset, is to repair the law in light of the 2019 court judgment and it being upheld by the Court of Appeal. And clauses 1 and 2 set out to do this. As I've said, clause 1 fixes the law looking back the ways and makes staff decisions lawful in retrospect, and clause 2 would allow staff to perform functions going forward. This clause 3, however, would empower the Department to create a registration threshold in advance of any formal policy decision by the Minister as to whether a threshold should even exist. Now, the Minister has stated that the creation and detail of any threshold is being considered by the broader independent review of charity regulation, and it may be possible that if this bill is passed, the registration threshold clause, this clause 3 here, may need to be amended further depending on what the independent review recommends to the Department and what the Department decides to take forward from that. So, given this, the committee might wish to consider 2 alternative approaches, and there's a greater and a lesser alternative here. So, first of all, the clause could be removed from the bill, and that would kind of be a maximalist approach, and then just included in any future legislation which arises from the broader independent review of charity regulation. And that could absolutely ensure that whatever that independent review recommends in terms of a threshold is definitely covered by the law that is passed to inform it and enforce it. The other option could be that the committee could seek assurances from the Department that this clause 3, as it currently stands, covers everything that the independent review could possibly recommend in a registration threshold, and there would be no need for further amendment. So that's the bill. Very briefly then, I'll just touch on some of the potential financial implications of the bill. So if enacted in its current form, there would be some additional costs arising from the bill. So development and consultation on a scheme of delegation for Commission staff, creating and altering Commission procedures to align with that scheme, and then training Commission staff on working within the scheme of delegation would all have some initial costs and maybe some recurrent costs as well, but probably relatively minor. On the other hand, then, staff delivery of Commission functions would actually probably be a saving on the current situation. And at the minute, the Commissioners themselves are taking a small number of decisions and actions on an ongoing basis, but it's not a particularly efficient way for them to be operating, which is why the bill is being introduced. And then secondly, then, I mentioned earlier that the bill would refresh the appeal window for some Commission staff decisions. This may result in additional appeals to the Charity Tribunal in the immediate wake of the bill's enactment. So there may be associated one-off costs to the public purse in terms of addressing those appeals and processing them through the charity tribunal and issuing decisions and that sort of thing. So that's me. I'm happy to take any questions or revisit anything or go into more detail on any particular area there. Thanks very much for your attention.
Thank you, Stephen. I appreciate that. Can I ask members if they could indicate if they want to ask Stephen any questions? Stephen, I just have one. I suppose you've raised lots and lots of issues there, and I suppose it's around the scheme of delegation, but further than that, actually much broader than that. When we look at the independent review and the amount of matters that they're considering, did you see that could create any further issues while we're considering the bill? I know you'd mentioned there about the clause 3 as well. Is there any other issues that would flag up?
Well, I suppose in terms of the bill, clause 1 and 2, as I say, I couldn't spot any issues. I could say that much. The clause 1, as I say, just fixes staff actions going back the ways, and clause 2 permits the department to create a structure to allow staff to perform functions going forward. In terms of clause 3, it does seem to be very broadly written. This is something probably for the department to say and advise on, but it does seem to do everything that you could possibly imagine that a charity registration threshold would need to have. You know, in terms of the detail of what it does, this is in the paper, but it allows the department to create an income threshold or an asset threshold that defines what income and assets are, and it allows the department and the commission to create differential rules for registered and unregistered charities. It allows an unregistered it would allow a charity that isn't required to register anyway if they wanted the badge or the seal of approval as such. So I couldn't spot anything that was missing. It was more that, and as I say, this kind of may be overcautious, which is why, you know, the clause could be taken out, or alternatively, the committee could just seek assurances from the department that it does the job. The main issue or the main concern that kind of arose in doing the research was it's a bit of a sore thumb in terms of the context of the bill. Clauses 1 and 2 fix the law in light of the court judgments, which is the point of the bill, and clause 3 kind of tacks on this other power for the department. It does seem like most parties and most stakeholders support some sort of registration threshold in future, but the detail of that hasn't been worked out. And given that there was a 2008 Act and then the 2013 Act which fixed the 2008 Act, and then this bill which will fix the Act again, you wouldn't want a situation where you're going back in to fix the charity registration threshold clause if it could be avoided. So as I say, I know that that's not massively helpful because I couldn't spot any individual specific issue. It's as much that it doesn't seem to be of a piece with the rest of the bill, and you wouldn't want to make a mistake through being hasty or putting the cart ahead of the horse, if you see what I mean.
No, thank you for that, and I fully understand. I sat on this committee in 2013 when we were looking at the bill at the time, and I remember quite a lot of evidence gathering and a lot of long sessions where we were debating it, and we're still in this position we're in now. So it's we want to make sure we get this right. Any member want to ask any question, Kelly?
Thank you very much, Chair. Thank you very much, Stephen. Congratulations. I hope you're getting some sleep. I just wanted to go back to clause 2, the point that you raised about where commissioners, and staff cannot, they can't have delegated powers and the commissioners have to take that. The point that you made about are they being advised, by staff? There isn't anything here that says that the commissioners have to be transparent in the papers that they're using in order to make their decisions. I'm just wondering if there's anything there that we should be thinking about, if staff are advising the commissioners, and they probably will have done the work on that, under data protection, can those sort of papers be produced publicly, and be on public record? I'm just wondering how we can make sure the process is as transparent as possible.
Well, just before I answer the question, I'm conscious I didn't thank the Chair and Kelly for the congratulations. She's pretty cooperative, so I'm sleeping okay. But in terms of how commission decisions would work in future, and how those decisions they must be taken by commissioners, but staff could possibly support. the bill itself, it doesn't say an awful lot about, transparency or that sort of thing, but that's really only a function of the fact that this bill does not replace in full the 2008 Act, it amends issues in it. So the 2008 Act elsewhere, for example, has, commits the Commission to upholding the highest standards of transparency and diligence and those sorts of standards in the conduct of their duties, and that is it's put a specific measure in the 2008 Act. There's sometimes I wouldn't want to get ahead of the department again, as I say, but I think that between the existing requirements in the 2008 Act for the Commission as a corporate entity and the commissioners themselves in this instance to uphold those sorts of standards, and then the detail that you would hope should be in the scheme of delegation that would line out how staff can interact with the commissioners in that context where the commissioners have to take the final decision. And then, the existing sort of data protection legislation kind of separate to that. Between those three, it should be pretty clear, but as I say, I don't want to get into any detail would be hypothetical at this stage, because the detail of the scheme of delegation would be quite important going forward in terms of lining out what staff at different levels can do, and particularly where decisions are reserved to commissioners, who, if it's a chief executive or a unit head, who is permitted to offer information or advice or have sight of material. So it's it would be a question for future scrutiny as much as anything else, I'm afraid.
Just have another question, Stephen, just on your point about clause 3. I do have concerns about thresholds. It's like, how long is a piece of string when you're setting a threshold for a charity? Because you could have a social housing or a housing association, and their assets, the value of their assets is going to be enormous because you're dealing with property. You could have transport companies whose assets are huge because the cost of accessible buses is a fortune. And then you might have others that don't have any assets. So setting a threshold, I would be worried that if this goes through, it could be a temptation for funders to use the threshold in order to restrict access to funding. And we've seen it already through COVID, the impact that had in restricting access to funding for national charities that actually deliver services here. So I am a bit concerned about that. I certainly would like to ask and tease that out with the department more. And you're saying that the threshold isn't set elsewhere in the UK?
So I'll just refer to a couple of notes on this. So in Scotland, the Republic of Ireland, there is no threshold.
Yeah.
In England and Wales, there are exempt charities, and there are charities which are exempt on a broad range of grounds, but it does include the registration threshold. So the Commission, for the Charity Commission in England and Wales, and the Secretary of State over there can specifically exempt individual charities by order if they have an income of less than £100,000 per year. If a charity's gross income is less than £5,000, they don't have to register at all. So, that is a flat threshold that applies to everyone. If you've got less than £5,000 a year, you're exempt from registering. You can if you want, but in effect, there is an income threshold below which a charity is not obliged to register in England and Wales, and that's £5,000. And then the Commission and the Secretary of State can exempt other individual charities if their income is less than 100,000. So that's the only place in terms of Great Britain and the Republic of Ireland where that kind of threshold exists. And there is, in light of what you're saying there is maybe some recognition of the fact that a charity of less than £5,000 a year, the one that always comes to mind, I imagine, is like a parent-teacher association, and they really just do maybe 3 or 4 grand's worth, maybe if they're doing well, of fundraising activities depending on the size of the school per year, but they've got all that paperwork. Whereas you could have a larger charity, or a charity which appears much larger, like you say, but it could be maybe a community transport network, and they just happen to own a dozen buses, but they've actually only got maybe 3 or 4 volunteers running them or something like that. And in that context, it looks like they've got a lot more, but it could still be quite disproportionate. So in England and Wales, as I say, if you're below 5,000 in income, you're flat out not required to register. If you're below 100,000, the Commission and Secretary of State can individually and deliberately exempt you. So that kind of setup might go some way to acknowledging that sort of difference that you're talking about there.
Okay, yeah, no, I understand that, because you know, small charities, especially those who are run completely by volunteers, don't have the capacity to do as much red tape. But that asks the question then, should we be allowing them to register with a much lesser amount of red tape in order that they can then access funding going forward? So I'm sure we'll tease this out with our investigations with groups coming forward. But thank you very much, Stephen. I wish mine was as good as yours was when she was wee, because for the first 3 weeks I don't think I slept 1 minute. Thank you.
Okay, thanks, Kelly. Any other member want to ask anything of Stephen? I don't see any hands up, or nobody else has indicated. No, well, that's okay. Look, Stephen, thank you very much. You have raised lots of questions there that we will fire on to the department. And thank you again. The RAIS have delivered on a very comprehensive piece of work. So thank you, Stephen, and go and enjoy that baby.
Yes, thank you very much.
Okay, thank you. Thanks, Stephen. Okay, members. So we'll do that. We'll send on some of those excuse me, questions that Stephen rose through to the department for answers. Okay. All right, we're going to move on to agenda item 7, which is departmental briefing on the betting, gaming, lotteries and amusements amendment bill. This is another tongue twister for us. Members, you'll find the bill at page 139, and can I welcome Kieran May and Martina Campbell to committee this morning. Is it yourself, Kieran, that's going to do the briefing for us?
Well, I think Martina's going to start off, Chair,
right, okay.
and then hand over to me.
Dead on, no problem. Go ahead, Martina.
Okay, good morning. Thanks for the opportunity to brief. So, the policy proposals which inform the content of the present bill have not changed since we briefed the committee earlier this year in May. Our aim today is to provide members with a pre-introductory overview of the structure and content of the bill as it currently stands. Before we do that, I'd like to make a few points about 2 issues. Firstly, online gambling, and secondly, timetabling. On online gambling, I want to be upfront and say at the outset that this bill does not legislate for any online activity. That is because the existing law, the 1985 order, is too old, and it was not possible to import modern day terms given the structure and language used in the 1985 order. However, in order to afford consumers here the same protections as elsewhere, Section 5 of the Gambling, Licensing and Advertising Act 2014 was extended to include consumers here. As we explained in May, because of the scale of reform needed, the Minister has decided to take a two-phased approach. The main reason being the short amount of time left in this mandate. It would simply not be physically possible to take a bill through which would overhaul the 1985 order. However, Minister was keen to address some of the issues which were raised in the most recent consultation. On timetabling, the bill itself is scheduled to be introduced next Tuesday, the 14th, and a second stage scheduled for the 27th, so it should hopefully be with committee on the 28th. Our aim is to have the bill enacted before the end of the present Assembly mandate, ideally late February. We recognise there are important Assembly scrutiny processes to go through before this, and a need to consider carefully any comments that you as a committee may have. I would want to assure the committee that we are keen to work with you over the coming months, and we see see this stage as vital in ensuring that any final legislation is as robust as possible. We're happy to take questions at the end, Chair, if that is acceptable.
Thank you.
So, okay, great. Thanks. Hand over to Karen.
Right, thanks, Martina. Chair, what I'm proposing to do, if it's okay with members, is to talk you through each of the bill clauses. I know you may have received copies from us previously, so hopefully if you have that in front of you, you can follow me as I go through. By way of sort of preliminary, I think I should just mention that this is essentially an amending bill. In other words, it amends parts of our existing gambling law, namely the 1985 Betting, Gaming, Lotteries and Amusements Order. It doesn't therefore replace or repeal the 1985 order. And the bill itself contains 16 clauses and one new schedule. These generally need to be read in conjunction with the 1985 order. So the 1985 order, if you like, to a large extent sits side by side with this bill. Structurally, it's important to point out as well that the 1985 order subdivides gambling activity into about 6 broad categories. And these are betting, bingo, gaming, lotteries, amusements and competitions, plus some related miscellaneous matters. And the 16 clauses, therefore, in our bill follow those pre-established categories. Clause 1 then, which deals with interpretation, also makes this clear by stating the references to the 1985 order in the bill mean the 1985 Betting, Gaming, Lotteries and Amusements Order. Clauses 2, 3 and 4 then of the bill deal wholly with betting as understood by the 1985 order. Clause 2, firstly, is designed to allow licensed bookmakers' offices to open for the transaction of business on Sundays and Good Fridays, but not on any Christmas Day. This amends Article 31(1) of the 1985 order, which currently prohibits bookmakers from opening on Sundays, Good Fridays and Christmas Day. Clause 3 follows from Clause 2. It's intended, in light of that Sunday opening provision, to make sure that bookmakers' office employees have the same protections against being required to work on Sundays as other types of workers. And that's achieved by amending the definition of betting worker in Schedule 8A of the 1985 order. That schedule deals with Sunday working, and Clause 3 basically inserts an additional provision into Article 53B of the 1985 order, which deals directly with Sunday observance law. Under Article 53B, Sunday observance law doesn't apply to track workers. It now won't apply to betting shop workers either. Clause 4 amends the current restriction in the 1985 order, which only allows registered pool promoters to carry on a pool betting business at licensed tracks. Clause 4 now will allow bookmakers' offices to run their own pool bets from their own premises, and this is subject to certain conditions which are set out in paragraph 3b of Clause 4. Clauses 5 and 6 focus on bingo clubs. Clause 5 changes the eligibility rules in the 1985 order governing who may play bingo at a bingo club. At present, the order allows a person employed in the bingo club premises, for example, a cleaner, to play bingo there without the need to be an eligible member. Clause 5 removes that employee provision so that only bona fide members or a guest of a bona fide member may play bingo at the club in future. The clause 5 further removes the requirement in the 1985 order that 24 hours must have elapsed from the time a new club member makes an application to join a commercial bingo club before they can play bingo there. In short, members and their guests may participate in bingo at the club without having any longer to complete a statutory waiting period. Clause 6 of the bill then deals with Sunday and Good Friday opening. It will allow bingo to take place and gaming machines to be used in bingo clubs on Sundays and Good Fridays, but not on any Christmas Day. Currently, both these activities are prohibited from taking place on Sundays, Good Fridays and Christmas Day at bingo clubs under Articles 76 and 108 of the 1985 Order. Clause 7 relates to the protection of children and young people. It creates a new offence of inviting, causing or permitting a person under 18 to play anything other than a lower limit gaming machine. It sets out a definition of what is meant by a lower limit machine, and that is where there is an amusement permit in force and the prize value does not exceed £8 as stipulated in Article 108(7) of the 1985 Order. Clause 7 also sets out the mode of prosecution and punishment for breaches of the new law on allowing people underage to use high-stakes gaming machines, but it also makes it a defence for a person charged to be able to prove that there was good reason to believe that an under 18 had attained that age. Clauses 8 and 9 cover lotteries and prize competitions. Clause 8 removes free-to-enter prize competitions from the definition of a lottery in Article 131 of the 1985 Order. Clause 8 also sets out what does and does not constitute a requirement to pay in order to be deemed a lottery. Clause 9 repeals the current £1 price limit on the sale of a society lottery ticket. It also repeals the provision in the 1985 Order on the maximum amount of the proceeds of a lottery which may be appropriated for expenses. That's currently set at 20% where the proceeds do not exceed £10,000 and 15% where they do exceed £10,000. Clause 9 replaces these with an across-the-board maximum of 20% in all cases, excluding prizes and irrespective of the proceeds amount. Most of the remainder of the bill, clauses 10 to 15, comprise a series of so-called miscellaneous amendments to the 1985 Order. Clause 10 amends the existing age, residency and incorporation requirements for receipt of bookmakers and bingo club licences, gaming machine certificates and permits and lottery certificates. In essence, Clause 10 reduces the age limit for receipt of those type of licences from 21 to 18. It removes the requirement as well for recipients of such licences, permits, etc. to be resident here. Clause 10 also allows certain corporate bodies to hold licences and certificates and to be granted amusement and pleasure permits. Currently, they're prevented from doing so under a range of different articles within the 1985 Order, all of which are cited in the bill. Clause 11 amends Article 168 of the 1985 Order. Article 168 presently prohibits the conduct of certain newspaper and other prize competitions here. The clause, in short, seeks to remove free-to-enter competitions from the Article 168 prohibition. Clause 12 replaces the existing offence of cheating in Article 169 with an entirely new offence. Clause 12 makes it an offence to cheat at gambling or assist others to cheat, irrespective of whether or not attempts to cheat are successful. It also contains a new definition of cheating. Clause 13 repeals Articles 170 and 171 of the 1985 Order. At the moment, Articles 170 and 171 effectively prevent gambling contracts from being legally enforced. Clause 13 does away with this so as to allow any future gambling contracts to be legally enforced, provided they're lawful in all other respects. Clause 14 makes provision for an industry or statutory levy. It allows DFC to make regulations for the payment of a levy to the department by the licensed gambling industry here. So in accordance with Clause 14, any regulations for imposing a gambling levy would be subject to affirmative resolution of the Assembly. Clause 14 further requires that any regulations incorporate provisions for the payment and administration of the levy. This includes determining the amount to be paid according to a specified formula or method. The clause also stipulates that any proceeds from the levy are to be expended by DFC on projects relating to gambling harm or addiction or other forms of harm or exploitation associated with gambling. Under Clause 14 as well, DFC will be required to consult with organisations that appear to us to represent the interests of the gambling industry here before we can make regulations for a levy. And any proposed expenditure of levy proceeds will also require DOF approval. Clause 15 imposes a new requirement on DFC to issue one or more codes of practice about the manner in which gambling facilities are provided. Codes of practice must ensure that gambling here is conducted in a fair and open way, that people under 18 and other vulnerable groups are protected from gambling harm, and that operators make assistance available to those who are or may be affected by problem gambling. Clause 15 also states that whilst failure to comply with any part of a code of practice doesn't in itself constitute a criminal offence, the code can be admitted in evidence in criminal or civil proceedings. Clause 15 further sets out arrangements which DFC must follow with regard to consulting and publishing codes of practice. It also allows the department to publish one or more codes and to revise or revoke any code. Clause 16 deals with how the legislation may be cited and arrangements for the coming into operation of the different sections of the bill once it receives royal assent. And finally, the bill includes a new schedule, Schedule 15A, which is to be added to the list of schedules at the back of the 1985 order. New Schedule 15A basically provides further detail and definitions as to how a requirement to pay to enter a lottery or prize competition should be interpreted in future under the order. And that's really a general run through the provisions. I'm sorry, Chair, that's a bit technical, but just wanted to run you through that. Thank you, Martina.
Okay, thanks. So to sum up, in our view, the provisions in this bill clearly justified fully reflect policy aims that we outlined to the committee in May. We feel that the bill offers a balanced package between relaxation and restriction in relation to land-based gambling. We feel too that it is realistic in terms of what is feasible in the short time frame remaining of this mandate. And we think it gives us important new regulatory powers and some much needed flexibility in terms of regulating gambling. The Minister has already said that in parallel with the introduction of this bill, she intends to bring forward, she intends to do more to help society lotteries to improve their income so that more funds can be raised for good causes. And she also intends to review the monetary limits around stakes and prizes for machine gaming and bingo clubs. These have remained stagnant for decades, whereas in Britain they're reviewed every 3 years. In that context, the Minister recently informed the committee about the introduction of a new statutory rule. This new rule removes the prohibition on the sale of lottery tickets on the internet, and that regulation came into effect this week. As of now, small charities and voluntary groups are no longer impeded from selling tickets online. The Minister believes that the other changes she wants increases in stakes and prize limits for society lotteries, machine gaming and bingo clubs can be delivered through secondary legislation, and we're currently developing detailed proposals around this, and we will of course keep the committee informed. Finally, all of our proposals have undergone the normal equality screenings and other impact assessments, and no adverse impacts have been identified. We will be publishing those impact assessments on our webpage shortly, and we're happy to share them with you if you wish. I'm happy to take questions, Chair.
Thank you, Martina. Thank you, Kieran. Bit of background noise there. Don't know where it came from, but we're all right. Excuse me. I suppose just from the offset, just as a committee, we need to be very clear as well that, you know, we maybe didn't get everything we wanted through this bill, but we understand the need to break it in two. So it's just we need to be mindful of that as we go through the evidence gathering within this bill. Kieran, you're absolutely right. A lot of that was very technical. I think I know certainly for myself, I can't speak for other members. It's an issue that I would not have had a great knowledge of. So I think as we go through the evidence gathering on this, it will become a lot more transparent, certainly for me, what many of the issues are. I know that there are several of us that do sit on the all-party group on gambling related harm. I know, Martina, you attend that as well as an observer. So we've been given, I suppose, a better insight through that group as well. So no, I look forward to certainly to getting stuck into this. I saw several raised eyebrows in the room when you mentioned February 2022. We will do our very best, so we will, to get to that stage. But as I've always said, that we will put in due diligence, and which is what we always do in this committee when it comes certainly to our legislation. So I'm happy with that. There are many questions I suppose we would want to ask, you know, around the levy, around further consultation, and issues that have been brought to us by people who are starting to write into the committee, you know, whether, you know, to do even with those various lotteries that are available in England but not available here. Will that make provision for that in this bill? And then on the issue of the levy, any conversations, preliminary conversations you're having with the industry, how is that going down with them? And you know, how is that going to be worked out, that levy? What way is it going to be done? Will it be percentage wise? What way is it going to happen?
Someone mentioned it to the industry, or some of the industry, and they're supportive in principle on the mechanics of how it would operate. We haven't had any discussions as yet because it's much too early in the process. That will all be subject to full consultation at a later stage.
Okay, no, that's great. And what about the issue to do with some of those lotteries then that are not available to Northern Ireland people? Is it included in this then as well? You know, the postcode lottery.
Yes, this is included in the bill, and we are hopeful that people will be able to participate in the like of Halifax, Sabre, Straw, Daily Mail, crossword, those type of things that we, as same as yourselves, get a great many representations on.
Chair, if you in the section in the bill they deal with, if you there's a section in the bill called Rules for Society Lotteries, and another section on prize competitions not requiring persons to pay to participate. Plus the schedule I mentioned, the new schedule I mentioned at the end, they basically cover that issue.
Okay, no, that's fine. No, I know certainly I've been contacted on a constituency level as well by people in the past about the likes of those competitions that are run through various newspapers, where someone does the competition and then finds out at the very end that because they live in Northern Ireland, they can't submit the application for that. So no, that's good. I'm going to open up to members. I have Alex, and then I have Sinead, and then I have Kelly. So can we bring in Alex first, please?
Can you hear me?
I can indeed, yeah. Alex, go ahead.
Your star, thank you. A couple of wee things.
is there anything in this in terms of banks or building societies, such because whenever they're doing wee competitions or stuff, it never includes Northern Ireland. So that's my first wee question, because I know it would have to come through this bill or another bill to get sorted out. That's my first wee question. Not sure about openings on Sundays, so I'll not say too much about that at the moment. And is there anything in the bill that will go towards helping problem gambling with addictions and stuff as well? So there are my three questions. And thank you for your comprehensive comments on the bill so far. Right. Alex, yeah, the banks and building societies issue is intended to be dealt with through those clauses which I just mentioned, the chair, the Rowntree Society Lotteries and the prize competitions. The clauses are in there, they're dealt with in there.
Okay, that's good.
The helping problem gambling, that would be the purpose of the levy that we mentioned. And also, really, it's the underlying purpose, part of the purpose of the codes of practice, which would be designed to encourage good practice on the part of gambling businesses and also encourage them to identify and provide support to people who may be vulnerable to gambling harm. I don't know if you want me us to say anything about Sunday opening or not, but
You'll be agreeing with it too much, but go ahead.
right. Basically, the issue with Sunday opening partly is that people can already gamble at racetracks on Sundays. They can also gamble online. They can go to amusement arcades and gamble. So this is really intended to correct what the industry see as an unfair targeting of them, just bookmaker shops. The other thing is it has to be read again in conjunction with the following provision, which provides protection for betting office workers who do not wish to work on a Sunday, that they're not required to do so necessarily. That's essentially that does. Okay, that's fine.
Okay, Alex?
Yeah, that's fine. Thank you.
Thank you, Alex. I then have Sinead. If I can bring Sinead in.
Hi, Chair, thank you, and thanks to Kieran and Martina for the briefing. Just on the levy, I think it's welcome that's included, that is going to be included in any amendment to the bill. I know from my own work on this, Sinn Féin have put together our own policy document in terms of problem gambling and how to tackle it. And when we looked at the levy issue, especially in the south, I know some land-based betting sites, they were very open to it. Very, in fact, I don't think there is a requirement on the gambling industry in the south at the minute to pay the levy, but some of them do it voluntarily. If I'm wrong on that, but that was my understanding of it. So yeah, and we have to bear in mind the fact that the likes of Dunlewy and Davina's Arc and other addiction services do great work, but there's no actual dedicated problem gambling service to help people here in the north. So if the levy was put towards something like that, I think it'd be very useful and very welcome. Just on the and this is where I get a bit confused, and it's not because it's not clear in terms of the briefing that you give, Kieran, going through the clauses. It's just probably the terminology for myself. I know I've been contacted by, I suppose you call them amusement arcades, so the likes of, you would see them here in Newcastle and the various holiday hotspots around the north, and I think they're slightly concerned that there's maybe an expectation from them that the amendment to the stakes and prizes amount would be bringing us in line with what's happening in Britain, when obviously the immediate competition for those places is across the border. And I think what they would like to see is a harmonisation of the stakes and prizes amounts island-wide, to just to give us that, so we can maintain that level of competitiveness with competition across the border. I know as well, and I stand to be correct, but my understanding is that the gaming machines that we have, certainly I know in the likes of Newcastle here, and I'm sure in other border areas as well, they're actually made in the EU, and they're programmed. They're programmed the same way the machines in say the south would be. So I don't know if that's a factor in terms of determining the amount of the stakes and prizes. Is it factored in actually where the machines are manufactured, and what they're set up to do in terms of the stakes and prizes? So just, I think maybe Martina, you alluded to the fact that that's probably something in the second phase of the bill, so it's maybe not an immediate thing for us to deal with at the minute, but I just wanted to throw it out there just to put it on your radar. And secondly, as well, in terms of the lottery piece, Kieran, again, just a wee bit of clarity. Are you saying, did you mention in your briefing that there's a removing of the clause that you have to actually be a resident in the state to claim the prize? And I think maybe that sort of feeds into that wider mention that Paula and Alex maybe had, where I know a big issue is, the bill won't go this far, but if there's a competition on RTE that viewers in the north can't enter, and I know that would need buy-in, that would need the government in the 26 counties to actually change their gambling legislation. But is there any sort of looking at that wider piece across the island in terms of those competitions? Because I think that's a big, certainly it's, anytime there's a competition on RTE, the Sunday game or anything like that there, my mentions on my social media blow up because people are really perplexed about it. So is there anything maybe further down the line, even looking at something like that? Obviously it would have to be in conjunction with the government in the 26 counties, but overall just happy that this piece of legislation is coming forward eventually. So thank you.
Okay, do you want me, Martina, deal with the lottery, and then do you want to do the stakes and prizes? Basically, the issue on the lottery, the two clauses I've mentioned are designed to address that. This is about really competitions that are free to enter, or else you can enter, you qualify for entry either because you've a bank account or maybe you buy a chocolate bar or whatever. So that all hinges on an issue around what is understood in the 1985 order by payment to participate. And that has largely deterred a lot of companies and businesses from offering their competitions here, because the purchase of certain products could be seen as payment to participate in a competition. So what we're doing in this bill is addressing that, actually seeking to address that actually now, by effectively providing clarity on what is defined by payment to participate, so that free to enterprise competitions such as you describe should be possible to offer to people resident here. Okay.
Okay, thanks. So you've raised a few issues there through the church here. So on the levy, first of all, we're really not having any detailed discussions at this stage, because there's a process to go through, firstly, of securing DOF and then Treasury approval to introduce the levy. So there's a bit of work, a massive piece of work there to be done, and then that will take in all of the issues around whether or not it's a set amount per premise, or whether it's a set amount per licence, or whether it's based a percentage based on gross gambling yield or whatever. All of that work is to be done down the line. On amusement arcades, we are currently looking at that. We know that we've had discussions with the NIACTA, the amusement industry governing body, and we know that they are keen for us to look at ROI limits, limits in size. We understand that the majority of machines are bought through manufacturers in England, and then they're adjusted to suit our limits. So that decision hasn't as yet been made, and as soon as we're in a position to share any of our thinking, we'll do that with you. On gaming machines, there seems to be a misunderstanding with the industry. I think that they think the stakes and prizes in the south is €5 and €5 maximum stake and €750 maximum prize. But our investigations have found that they're closer to the limits in England, Scotland and Wales of €5 and €500 maximum prize. Of course, in the south, there is only one category of gaming machine, which makes things a bit simpler for them and a little bit more complicated for us. But to answer your question in short, there's no decision being made as yet on the maximum stakes and prizes, further than the Minister has indicated she intends to look at the matter.
Okay. No, sorry, my machine cut out halfway through your response there, Kieran, in case you were...
Yeah, no, it's all Sinead. Yeah.
But no, I'll watch this back later on, but you know, that's fine, that's perfect. And I suppose that'll probably settle the nerves a wee bit, Martina, just that there's still time for the industry to have their sort of maybe their input or their say in that debate. As you said, it will become in the second phase of these amendments. So no, that's perfect. Thanks very much.
Okay, thanks.
Thank you.
Thank you, Sinead. We'll go to Kelly and then Mark after that. So Kelly first.
Thank you very much, Chair, and thank you very much, Martina and Kieran, for your update today. Just going to go to the levy, and I know it's very early days with the levy, but I'm quite interested to see how the discussions are perhaps going with yourselves and the Department of Health. If we're looking to address addiction services, I would be expecting some of that levy to go towards those types of services and help with problem gambling. We know that health looks after substance abuse. And it wouldn't be for the Department for Communities to be delivering addiction services. So I'm just wondering when the consideration is made or what the discussions are at this very early stage with health to see how that levy could be effectively used to address addiction services for gambling.
Yes, sorry, I should have mentioned that in relation to Sinead's point as well. So the 4 chairs of the all-party groups wrote to Minister fairly recently suggesting that there needed to be some cross-departmental collaboration. We already had some contact with officials in the Department of Health. So with using the letter from the APG chairs, Minister wrote to her colleagues in Department of Education and Department of Health, and we are in the process of establishing a cross-departmental group which will look at some of the issues around the health promotion and how we get it across, particularly to children, that what is gambling, what is not gambling, and what are some of the indicators of potential harm. So in terms of education, GamCare are launching an education project towards the end of the month, and Department of Education have advised us that their gambling is already covered within one of their, I think it's life skills or some of the subjects. On health, you're right, there's no specific standalone addiction service for gambling, and certainly that would be one of the issues that we would imagine the levy would fund, and the money that would be raised from the levy, it is envisaged that that will come into the department. The industry will have no control over it, and that we would, using normal procurement methods, procure services as dictated by Department of Health, who would have the lead on the treatment of problem gambling.
Thank you. I know that you've said this is an amending piece of legislation. It's not going to deal with the online gambling issue. I'm just a bit concerned how the sector, the businesses that are going to be providing the levy will feel about the fact that some of the problems that are being created by organisations that don't fall within this scope, or even what's going to happen in the future with those organisations that could be based anywhere in the world. So it's going to be a difficult one, but it's not for this legislation. I appreciate that, but it's certainly something I feel for the companies who are working with you, who are keen to have a levy and keen to see addictions being dealt with. So for another day, we'll deal with the online issues. Thank you very much.
Sorry, I should just add that the Turk Guardians Association does provide a small amount of funding to Dunlewy Substance Advice Centre for treatment of problem gambling.
Yeah.
Okay. All right, Kelly?
Yeah, thank you.
Okay, thank you. Can we bring Mark in then, please? Go ahead, Mark.
Thank you, Chair, and thanks to Martina and Kieran. Kelly had just made a point there that I think I'd made previously and was going to reiterate in terms of the levy, that it's going to be hitting the businesses who are already employing people here, already paying rates here and contributing in that way. That's not to dismiss from the damage that gambling is inevitably doing or inarguably doing to some people and to families as well, and not let them off the hook in that respect. But it's just a wonder if we're able to look at the percentages of money spent on gambling online compared to now on the high street, and I'm sure you'd find that most of it is going online. And it's just in terms of the levy, and I appreciate you say it's early days in terms of design or discussions with what it might look like.
Mark, your sound has gone off on us for some reason.
I think it's a fire alarm. Is it a fire?
I can hear from you, man. It's not in my house.
Okay.
It's gone.
There, it's off now.
No. I was speaking just in terms of the levy. Okay, if we are hoping, as Martina I think says, that this could be operational by February. Okay, this legislation will be passed and signed, sealed, delivered by February. Did you say, Martina? Now, to me, the most complicated and complex part of this legislation, and the decision has been made that we'll do two different pieces of legislation to do with gambling. And I'd have thought that, okay, we're going for the low-hanging fruit first, and fair the more difficult stuff. To me, whenever approval is still required from Department of Finance and Treasury, I don't know if discussions opened there even. Have we any idea how long those discussions will take, or a decision there will take? I think February sounding more ambitious after hearing that part of the conversation.
Sorry, yes. I suppose what I should say is that what we're doing in this bill is taking an enabling power. So the meat, if you like, around what the levy will do, how it will work, who it will apply to,
Martina, can
all
I
of
just
that.
stop you 1 wee minute? Sorry, are you and Kieran in the same room?
Yeah, we are.
Kieran, put yours on mute, will you, while Martina's speaking, because we're getting
taken mine down, yes.
Yeah, we're getting terrible feedback. Just
Yeah.
sorry,
Yeah,
Martina.
I've taken mine off.
Okay, go ahead, Martina. Oh, we've just muted Martina and I. So we have.
So the meat of it all
I'm muted.
will be dealt with in secondary legislation. So I think that will take out some of the heat around that we will work at the future.
Mark,
Okay,
did you
but-
get that? I know I don't know what the issue is. There's a bit of an echo there at the minute for some reason.
No, I heard it, but I'm not sure that I get it. I would say that this is such a crucial part of this legislation. You know, are we right to leave it to secondary legislation? Should that sort of issue not be on the face of the bill?
I think it's two speakers.
Hold on, two texts, Sean. Hold on, just 1 moment, everybody. Sean, go ahead.
The broadcasting team have advised that when Martina is speaking, make sure Kieran is muted and vice versa.
Okay. Well, we did do that. Kieran did mute himself there, didn't you?
They also advised that there were headphones, to see the headphones on.
Yeah, headphones are on now. So there, we'll try that again, Martina. Or sorry, Mark, it was yourself we couldn't hear properly there. Mark, could you pick up where you were?
It was me, but it wasn't my fault.
That's perfect now. Go ahead.
Yeah, no, it was just in terms of the detail of the levy, rather than coming to secondary legislation, should something of that significance and importance to this legislation and to society, we have to look at the purpose or rationale behind the bill, and while some of the others are amending clauses or tinkering bits here and there, with the exception of the Sunday and Good Friday opening, and this levy clause, which is huge and really important, should the detail of it not be on the face of the bill?
Yes, I get your point, but if we were to include all of the detail in this bill, the bill would never get through.
So sorry, Martina, is it just a desire to get this through in this mandate? It'll give an enabling legislation just so a minister can say, oh look, I got this through, you know, rather than have the actual work done and have solid proposals as to what this is going to look like and what it's going to achieve and how it's going to people.
I don't think it's as crass as that. What we're planning on doing is that we, to secure Treasury approval to introduce a levy and for us to keep the proceeds of the levy is a long, drawn-out process. Mm-hmm. So what Minister is doing is signalling to the industry that she intends to introduce a levy, and it gives the industry an opportunity to get their house in order and to work together to perhaps come up with a more substantial voluntary contribution, similar to what they have in the South. At the moment, the South have a voluntary levy, which is currently raising in excess of €1 million per year. So, albeit we are not on the same size, but the current amount of voluntary contribution, which is coming from one small sector, could be improved, and that could be worked on at the same time as we are developing the business case and negotiating with DOF and Treasury.
Okay, so it'll be used then just as to apply pressure on the industry in the interim to start coughing up before they have to?
Well, that's one way of looking at it. We see it as opening discussions.
Yeah. No, it's just whenever then we can ask what is foreseen is going to be in the second piece of gambling legislation that didn't make the cut for this amending bill. You know,
Okay, so the second piece of second phase would be a complete overhaul of the 1985 order. So the current Gambling Act 2005 has 362 clauses and 18 schedules. So what we would envisage in the second phase is a bill of that magnitude, and the current biggest bill that has gone through the Assembly was the Planning Act in 2010-2011, and that had 255 clauses. So the next bill is going to be at least a third bigger. So that's the scale of the task that's ahead of us. And what we're doing now is our best attempt to address some of the issues that exist around the land-based gambling.
okay, no, I appreciate that. Okay, thank you. And just in terms of the Sunday opening, a few points have been made there. I think it was you, Kieran, in terms of why. And just, you did a good job on that. The one that you did miss again, in border constituencies like my own, people can just nip 5 minutes down the road and go into a bet shop and put on a bet on a Sunday. And it's also worth pointing out that on Sundays now, I don't know the data from online companies or whatever, but many of our biggest sporting events actually reach the crescendo on Sundays or Sunday evening, so it's probably going to be a busy betting day as well.
Yeah, I mean, Mark, the industry's changed so much that it's possible now to gamble in so many different ways on a Sunday without going to the bookies, for example. So it is anomalous, I think, in our view, that you can gamble in so many other ways, but we're telling the bookmaker shops you can't open or gamble. It just doesn't seem, from our point of view, in terms of allowing fair business practice, it just doesn't seem appropriate any longer.
Okay, no, thank you. Thanks, Kieran. Thanks, Martina.
Okay, thank you, Mark. No other member has wants to ask anything further at this stage. Can I thank both yourselves, both Kieran and Martina, for coming in and joining us today. I know that we will have a very close relationship in the coming months ahead. So I look forward to welcoming you back, and I look forward, actually, I think the committee looks forward to getting stuck into this bill as well. So thank you.
Okay, thanks very much indeed, everyone. Thank you.
Bye-bye. All right, members, we're going to move swiftly on. We have several SL1s and SRs to get through, so we're going to push on with those. So I'm going to go to agenda item 11, which is SL1, the Private Tenancies Coronavirus Modifications No. 2 Regulations. You find a copy of this SL1 at page 557 of your pack. The proposed rule will extend the emergency period to the 4th of May 2022, which is the final extension allowed under the Private Tenancies Coronavirus Modifications Act Northern Ireland 2020. Can I ask members, are they any comments, or are they content for the Department to proceed to make this rule? Content? Yeah?
Content and absolutely delighted we have this extension for people.
Good. Thank you. Yes, you're quite right, Kelly. Okay, we're going to move on then to agenda item 12, SL1, the Social Security Benefits Amendment Regulations, Northern Ireland 2021. You'll find this SL1 at page 561. These regulations will provide the Department with the ability to make these payments in instalments with the claimant's consent and will provide an additional safeguard for vulnerable claimants. This is viewed as a positive change to increase the flexibility for claimants as to how they can receive the money they are owed by the Department. Again, can I ask members, have you any comments? Are you content that the Department proceed to make this rule?
Agreed.
Content?
Yeah.
Yeah.
Content.
Okay, we'll move on to agenda item 13, SL1, the Universal Credit Childcare Costs Amendment Regulations, Northern Ireland 2021. You'll find this SL1 at page 566. This proposed rule will amend the Universal Credit Regulations Northern Ireland 2016 by ensuring that an advisor discretion fund payment from the Department for upfront childcare costs will be included in the person's Universal Credit account for the purposes of calculating the award of the UC childcare costs element. So again, members, any comments? Are you content that the Department proceed to make the rule? Go ahead, Kelly.
I'm just saying, whenever I see discretion coming up with a piece of legislation, while I'm content for this to go through, I would like the Department to provide what the discretion criteria is, because it doesn't seem to be the same across the whole of Northern Ireland when it comes to discretionary support. So let's see what that means.
Okay, that's fine. We can ask for that. Members, any other comments or content that we proceed? Content? Okay. Then I'll move you on to agenda item 14, which is SR 2021/207, the Social Security Reciprocal Agreement Miscellaneous Amendments Regulations Northern Ireland 2021. You'll find this at page 571 of your pack. Can I ask members, have you any objections to this rule?
No.
No objections. Then I put the following, that the Committee for Communities has considered SR 2021/207, the Social Security Reciprocal Agreements Miscellaneous Amendment Regulations, Northern Ireland 2021, and subject to the Examiner of Statutory Rules report, has no objection to the rule. We can move on then to agenda item 15, which is SR 2021/215, the Social Security Fines, Deductions from Benefits Regulations Northern Ireland 2021. You'll find this at page 281 of your packs. Can I then again ask members, have you any objections to this rule?
No.
No objections. Then I'll put the following, that the Committee for Communities has considered SR 2021/215, the Social Security Fines, Deductions from Benefits Regulations Northern Ireland 2021, and subject to the Examiner of Statutory Rules report, has no objections to the rule. Moving on then to agenda item 16, which is SR 2021/232, the Lotteries Amendment Regulations Northern Ireland 2021. You'll find a copy of this at page 590 of your pack. Again, members, have you any objections to this rule?
No.
No objections. Then I'll put the following, that the Committee for Communities has considered SR 2021/232, the Lotteries Amendment Regulations Northern Ireland 2021, and subject to the Examiner of Statutory Rules report, has no objections to the rule. I'll move on then to agenda item 17, which is correspondence. Members, you'll find the correspondence memo at page 598, and I just want to draw your attention to page 653, which is a memo from the Agriculture, Environment and Rural Affairs Committee asking for views on the Climate Change No. 2 bill. Members, the bill will place a responsibility on all executive departments to ensure that greenhouse gas emissions do not exceed and set carbon budget for any period. With this in mind, are you content that response is drafted for agreement at a future meeting, which focuses on DFC's responsibilities, such as ensuring new housing or new social housing is built to higher efficiency standards, retrofitting where financially viable existing social housing stock, ensuring the continuation of schemes such as the boiler replacement scheme and warm home schemes, and ensuring that the department's offices are as energy efficient as possible. Members, any comment on that? Agree? Kelly?
I agree, but we need to add into that we've agreed the pensions legislation that encourages for environmental investments.
Yeah, that's correct.
We've got lots there. Yeah.
Yeah. Okay. Any other members? Any comment on that, or are you happy that we agree that?
Agreed.
Yeah. Okay. Members, then in the last set of summer recess correspondence emailed out on the 3rd of December, we received a ministerial response on the LOTS scheme. Members, are you agreed that we forward this response to the Belfast Metropolitan Residents Group who raised the matter with us originally? Agreed?
Agreed.
Okay. Okay, I'm going to ask members then if you anything that you want to bring up under correspondence at this stage? No? Are we all right? Okay. Happy enough, people? Yeah? Okay. Then I'm going to move on to agenda item 18, which is our forward work programme. You'll find a copy of a draft forward work programme that was emailed to you. I propose that we now agree to discuss this in greater detail at next week's meeting. Are members agreed with that?
Agreed.
Yeah?
Agreed.
All right. Then I'm going to move on to agenda item 19, which is any other business. Members, any other business you want to bring up? Kelly?
I was just going to ask if it's okay with the committee. I know we talked about the WICT partnership earlier, but we do have an issue where communities will be looking at the refugees who are going to be coming in. I haven't had any feedback from the department yet on the preparations. Can we maybe write as a committee to the department just to ask them for an update?
Yeah, and there was money at one stage that the department were doing with was it the Syrian refugees at the time? So I think
that's it. It's the executive office leading it, but communities obviously has to take a key role there as well.
Yeah.
No, I think that would be yeah, definitely. I know, Kelly, you have written.
I've written to Tracy Maharg, the Permanent Secretary, but I haven't heard anything back yet. As Mark says, it could well be that it's all being planned through the Executive Office, but the housing arrangements are going to be under communities. So I think we just need to find out, are they okay? Do they need our support? You know, it's not to kick the department, it's just to show that we are willing, able and want to help them. Yeah.
No, I was on a meeting yesterday and there are now 5 hotels are being used. There's one in Newtonabbey, one in Carrickfergus, 3 in Belfast are being used at present. So they are. So because we don't have the housing stock here in Northern Ireland to cope. So yeah, that's a conversation that needs to happen. What DFC's responsibility is. Members happy with that? Yeah. Anything else members want to bring up under AOB? Yeah, sorry, Andy, just first, and then I'll bring you in, Mark. Andy, go ahead.
Yeah, Chair, for fear of sounding like a broken record, and members will know probably where I'm going with this, can we, as a committee, write again to the Executive Office, highlighting our frustration that it would appear that welfare mitigation legislation has still not made it onto the Executive agenda, and basically highlight that we feel that we as a committee and those who are impacted by these loopholes that can't be closed deserve an explanation as to why it has not come forward yet.
Okay, no, I'm happy enough that we get a full explanation on that.
And just a second point, apologies Mark, everybody across the committee obviously will be concerned by the significant rise in energy costs. I'm just wondering if we as a committee can maybe look at that, what we can do. Is it perhaps writing to the Chancellor? I know we previously wrote reinforcing the DWP regarding the £20 per week universal credit uplift. But can we maybe look at the winter fuel payment, expanding the criteria, eligibility criteria, expanding the amount, and also write to the Executive to ask what considerations they will be bringing forward to support those who will be most impacted by these significant increases right across society?
I think that's a good point, and I know on a second response that I did on behalf of the committee, I'd put in about rising fuel costs, which, yeah, when we found the rising fuel costs, we didn't realise would be rising quite so much as what they have risen. So no, I think you're absolutely right. We need to find out more information on that. Mark?
Thank you, Chair. First, I'd like to say certainly agree with Andy on the issues he has raised there. Mine was a different one, and it's pertaining to the High Street voucher scheme, which is obviously a Department of Economy scheme. But I mean, it's changed a lot since it was first announced, and everyone was going to get £100, or it might have been more when it was first announced. Yeah. But members will have been made aware, or maybe some are more familiar with others, around the application process that's now been drawn up for this, and it requires online applications, and I'd have serious concerns that it's going to disadvantage all those people who don't have access to online services or the literacy to use them. Now, I've written to the Minister for Communities asking if she can liaise with the Economy Minister, because people are going to have to go on and apply and give a load of data and information that the Department for Communities already has. So I don't know if there's any scope for the committee to do anything to maybe back up my request or whatever, but I do think there's a serious issue there around access that people were struggling with beforehand, but now things have moved on so far and so fast over the course of the pandemic that there's people out there just completely struggling with so much having moved to online, and now they're going to get penalised or lose out, on something to which they're entitled as a result.
No, I think you're right, Mark. I mean, there's a huge database of people certainly who are claiming one benefit or another, or not don't even like calling benefits, but are part of the welfare system. So there's a huge database there that actually proves identity of people, and shouldn't need to be replicated again. And I know you will all have had it through your own offices to do with the COVID passports, and how the use of a driving licence was much more helpful than the use of a passport, because they could log on to that system or they could connect to that system. So I think there probably is a piece of work that it would need to be done sooner rather than later, because time pressures with this, that will assist people that don't have that access or maybe unable to complete the online application.
It would also take huge pressure off the system. If you could pay out so many people automatically, then it's less likely to crash in the first 5 minutes.
Yeah, and I mean, even the electoral, whenever you're going onto the electoral register, it uses the database that DFC has to verify identity. So yeah, it would be worth asking the question. I think it's a good point. Yeah, you'll do that. Okay, members, any other business members want to bring up at this stage? Nope. Okay, we'll move on then to agenda item 20, which is date, time and location of our next meeting. Our next meeting then will take place here next Thursday, the 16th of September, at the wonderful time of 9 a.m. in room 29. So members, thank you very much. Thank you.